Judge.
I join.
The state opposes that challenge.
You just give me a moment to find my notes, and I'm ready when you are, Mr. Buchal.
Juror number 135 said in the questionnaire that Juror 135 was supportive of Antifa. Antifa was good for Portland to stem the tide of fascism and anti-democratic movements. Had views that the First Amendment does not protect hate speech. Has participated in many protests. They're heard about the incident, and that's about what we've got. This is
Oh, she's the one that has no religion?
Doesn't agree with the Christian religion.
35 didn't agree with the Christian religion.
Oh, I'm sorry.
No, I don't.
That's that sure. I think that's a different sure. I think. Yeah.
Okay. I mean, what we have here is we have, you couldn't help notice coming into the courtroom this morning that there's a giant sign, defund hate, and there's this ideology that regards certain groups as hateful, and we do not think that people who are really fully wrapped up in that ideology, like Juror 135 is, can be biased. I understand that, maybe they think they can, but I don't
Don't think they can be unbiased.
don't think they can be unbiased. I understand they think they can, and this juror in particular may think that this juror can, but it's unrealistic given the intensity of the words that were used and the support for Antifa here.
Thank you, Mr. Buchal. Mr. Schmantzes, anything to add?
Nothing to add in addition to that.
Nothing to add. Mr. Hugh.
Your Honor, this juror explained that when they indicated that they were supportive of Antifa, to them that meant that they were supportive of the idea of being anti-fascism. When the question was sort of narrowed and put to them in the context of a singular organization, and you heard Prosecuting Antifa, the answer was yes, but Antifa is not one thing. And then the next question was, well, okay, Prosecuting Antifa, do you support them? And the answer was, I could, but I don't even really know what they're about, other than it sounds like from the name they support anti-fascism. Saying that somebody that opposes hate or fascism somehow can't be biased is not going to give rise to a for-cause challenge. I would further point out that the only mention of Patriot Prayer that this juror had heard, they indicated was from the questionnaire itself, and that otherwise they knew nothing about it, and that they could be aware of biases, work around them, and apply the law.
Thank you, Mr. Hughey. I agree with the state with respect to this juror. It was clear that she was distinguishing between a philosophy and a group of people. She was nuanced in that. She it was about property damage, but was not protective of any particular group. I'm not satisfied that Juror 135 is incapable or wouldn't try this case fairly and impartially. I believe she would. And so all defendants motion to excuse Juror 135 for cause is denied. Juror 135 is not released for cause.
139, Your Honor.
Thank you. Ready when you're, oh, well, I'm sorry. I'll check in with the other lawyers.
And I'll join with that, Judge.
Thank you, Mr. Schmantzes. Thank you.
The state opposes, Your Honor.
Thank you.
Sorry.
Mr. Buchal.
This juror said in the questionnaire that the actions of Patriot Prayer appear threatening to me and my community. And in response to the question as to whether they had personal beliefs that would make it difficult for them to sit on the case, said, I read about the fights in front of Cider Riot in 2019. All of them need to shut up and go back to work. Now, that doesn't quite explain, why that personal belief would do it. But when it's part and parcel of a threat to the community, I think it's invoking these other things. And then we have the associations of participating in marches, the Women's March, marches against gun violence. I understand that this juror lumped Patriot Prayer in with other kinds of right-wing groups, but the juror said that the juror absorbed the factual narrative from these things and got a, quote, strongly negative view of Patriot Prayer. And so we think that the juror also admitted that the job of being a juror would be hard to be impartial, was asked whether the incident and hearing about the incident makes a difference, and said yes. And then the most that the state was able to do was to rehabilitate, was to elicit some testimony about how a personal friend of this juror came to some event wearing a Let's Go Brandon t-shirt, and that didn't ruin the evening, perhaps, from one image. But we're not talking about one image. We're talking about someone who has absorbed a media narrative that gives them a seriously negative view of Patriot Prayer, and on that basis we move to exclude for cause.
Mr. Buchal, Mr. Schultz, has anything to add?
Yes, Judge. Juror 139 said they associate the Gadsden flag, which is Don't Tread on Me flag, with extremist hate groups. They had a negative view of that as well. They said they'd read about the Cider Riot incident in 2019 and had a strongly negative view of Patriot Prayer. Based on that, I think this juror is too close to the case and has too much prior exposure to it to serve openly.
Thank you. Mr. Doyle? I agree with both. Thank you. Mr. Hughey for the state.
Yeah, from the questionnaire, this juror indicated that both groups that were inquired about in the questionnaire, Antifa and Patriot Prayer, really they viewed them in the same light, that both, I think they used the term childish with respect to both groups. And I interpreted the anecdote that this juror offered as more meaningful than Mr. Buchal did. And I think the juror's intent was to illustrate that a first impression of something may be one thing, if it sort of rubs you the wrong way, but when there is a broader context and more facts to actually base an opinion on or form an opinion from, that is what is going to cause this juror to form a conclusion. And I think they were using that to illustrate to the court that they could be fair and impartial and confine their decision to the evidence in the case.
Thank you, counsel. Does that conclude your presentation?
I think so. Thank you.
Thanks. With respect to Juror 139, I agree with defendants. Just to be clear, only because Mr. Buchal brought it up, I continue to view a potential juror's participation in other marches or rallies that don't have anything to do with these defendants. That doesn't carry a lot of weight for me in this case. But in respect to Juror 139, the fact that he had read articles about the incident around which this trial revolves, and was left from reading those articles with a strongly negative impression of the Patriot Prayer folks who were there. I think Mr. Schmantz's put it best. I think that's just too close. I think he has a clear memory of what he thought about the people involved from this very event. That is sufficient to satisfy me. That notwithstanding his best efforts, which I think he was sincere about, Juror 139 could not try the issue in this trial without prejudice to the substantial rights of the defendants, and for that reason, defendants' joint request to remove Juror 139 for cause is granted.
140.
Thank you.
Judge, I'll join.
Thank you.
I'll join.
Very well.
And the state opposes.
Thank you. Ready when you are, Mr. Buchal.
This juror responded to the questionnaire by saying that Patriot Prayer, as well as Antifa, had demonstrated violence. And what was more of a problematic was the notion that the juror reported in the questionnaire that some members of the group have been convicted of crimes, which we think will be transformed into sort of other acts evidence and create sort of a Rule 404 bias there. There's further testimony in the questionnaire that the group has been reported on TV to have escalated to violence when protesting. That being said, I understand that the juror then declared that the juror didn't have as much as much facts as the juror would like to, but it seemed that the juror had a strong negative view of Patriot Prayer.
Thank you, counsel. Mr. Schmuntz.
Nothing to add to that, Judge.
Thank you, Mr. Scott. Mr. Hughey.
Your Honor, the state's opposition stems from the fact that this juror's any pre-existing sort of distaste they had for the Patriot Prayer group or their knowledge of Patriot Prayer as a group was shared mutually with Antifa. And then even when the juror was pressed to concede related to Patriot Prayer that they had a negative view, they quickly added, I think this is a direct quote, but again, I don't have enough facts to make a decent judgment. Again, I didn't do research on this. And then the pointed question was put to them by a defense attorney, I don't remember who. And the question was, will your irritation with those groups be manifesting towards my client? The answer was confidently and immediately no. I think the court is bound to rely on that because there's nothing from the responses of voir dire that suggests that's not something they can do.
I don't know if I'm bound to rely on it, but I do. I agree with the state. I think the juror was very clear that there was no significant bias and that this juror was willing and able to try this case impartially. All defendants requested to release juror 140 for cause is denied.
142.
Thank you.
I'll join, Judge.
Thank you.
Oh, I'm joined. Yes.
And we would concede 142.
Very well. I agree that juror 142 should be, and juror 142 hereby is released for cause with the stipulation of all the parties.
146.
I'll join, Judge.
Thank you.
You bet.
Thank you.
And the state concedes 146 as well.
Very well. I also agree that juror 146 should be excused for cause, and juror 146 is therefore excused for cause with the agreement of all parties.
.147 is an interesting case. This is a man who raised his hands when asked whether there would be ability to be impartial. And there's something about the murder trial of his brother. Withdrawn.
No motion as to 147.
Withdrawn.
Thank you. Does anyone else, just since we're on 147, does anyone else wish to argue 147?
I
now?
would withdraw.
Okay.
No,
Your
Honor. I'll withdraw.
I understand no party is therefore seeking to have juror 147. I know we're going out of order, but since we're here. Okay. Take a minute if you need it. Otherwise, ready for your next.
151.
Thank you. 151.
I don't join, Judge.
Thank you.
I do not have that juror on my list,
Very well.
negatively.
And the state opposes the challenge.
Thank you. Mr. Buchal.
This was the juror who had the conversation with people she trusted who were highly hostile to Patriot Prayer, violent clashes. And what gives us concern about this one is that this juror is in a relationship with an extreme amount of trust. I believe the word polyamorous was used. And we think that someone who is bound up that tightly with people who are talking about how Joey Gibson is the leader of Patriot Prayer, how there's clashes with Antifa, violent clashes, poses too great a risk to unbiased decision-making.
Thank you, Mr. Buchal. I'll hear from any other defendant after I hear from the state if any defendant wants to object, wants to join the state in objecting. Mr. Hughey.
Your Honor, in the state's view, 151 is not really even a close call in that the challenge should be denied. This this juror, I disagree with the characterization that she had strong feelings about either groups. The juror indicated that they had only lived here for about 3.5 years, really did not know the nature of these groups, did, I think, a pretty complimentary job of removing herself from potentially learning more in between the special panel and the jury selection. And the trust argument, I don't think carries much water. They were leading questions about, well, these are your friends, people you trust, that sort of thing. But she qualified those answers with, well, I had no information otherwise, but then immediately walked away. I think that this juror certainly can be fair and impartial, and their answers reflected that.
Thank you, Mr. Hughey. Did Mr. Schmontes or Mr. Doyle wish to be heard?
No.
I wish to be heard just because this is an interesting case in that she came forward to admit that there might be some prejudice, and then she walked us through the steps. I'm not sure how this is going to cut, but this is a very careful juror. So I will not join in for cause.
Thank you, Mr. Doyle. Picking up on that point, certainly Juror 151 demonstrated that she was able and willing to follow the rules, and so I have no doubt about her intent to do her best to be unbiased. The question is whether the thing she revealed suggests that she has been tainted with bias in some way. I don't think it does. She heard a remark at a barbecue. She walked away. The fact that she may like and trust the person who made the remark, I don't think, certainly does not satisfy me that she's unable to try this case impartially. I believe she is. Mr. Gibson's request that Juror 151 be removed for cause is denied.
Okay. 166.
Thank you.
Join in that, Judge.
Thank you.
I'll join in that.
Thank you.
And the state opposes that challenge.
Thank you, Mr. Buchal, whenever you're ready.
This is the current list from the court.
It was the dude we talked to yesterday. Glad so.
Well, here's yesterday's list. I'm sorry, I failed to hear the state's position.
The state opposes.
Okay. With respect to 166, this is a juror who answered the questionnaire by saying that Patriot Prayer is a hate group, again invoking this general indoctrination against hate groups, and said it was not good for Portland because all the incidents that he was familiar with were for promoting violence and hate. He was questioned at some length, and he's an intelligent man, but he has strongly held these negative views since 2019. He says there's no chance those views will change. He says that he, thinks he can reinterpret things, but we don't believe he has the ability to do that. He talked at some length about what a hate group means to him. He talked in great detail about what he thought Patriot Prayer was: Christian nationalists, elements of white supremacy, Christian nationalists, racist, white supremacist views. He says anybody who's a part of a group like that I view very negatively. He said he had been exposed to multiple incidents, 5 or so, from 2019 and 2020. That's an extraordinarily sharp memory for a potential juror. He saw a pattern. He said a pattern of events. He saw he very and then we asked him if his mind would change, like, for example, about the racist stuff. If we showed him that, here's Patriot Prayer, these white nationalist racists who are there on the sidewalk with multiple black men. And he said no. And to me, that indicates that there's something going on there. And one of the interesting things is that one of the very last things he said was that this Christian nationalist view carries what he's called global significance. And then he said verbatim that he was essentially hoping to hear evidence that they were guilty or not innocent. And it just passed by. So when he says he can compartmentalize all this global view, I'd ask Your Honor to contrast him with Juror 81, who was sitting in that chair over there. And she's the one who sort of at the end of she said, globally, I can't, because of the global significance of this hate thing, recognized in the ability to be unbiased. And this world view that attributes, global, save the world importance to regarding this group as so, primordially evil and that must be destroyed is not something that can be set aside.
Thank you.
Nothing to add, Judge.
Mr. Doyle.
Just the more that we heard, the more disturbed I got. I mean, at first I really liked him because he knew how to ask to use the John, and he did it twice, and I thought that was nice. But then the
Certainly
more
was an improvement, too.
yes. But then the more questions that were asked, and the more of his answers, I'm going, oh my God, this man's mind is so made up. It will not change, and it cannot be changed, no matter what the testimony is.
Thank you, Mr. Doyle. Mr. Hughey.
From the state's view, this prospective juror was candid, but then and demonstrated the gravity that he viewed as being important to this process, pointing out that being fair and impartial is a constitutional right that he would absolutely want for himself, and would want somebody to be a juror like he said he could be, that would be clear that they're evaluating the case fairly and impartially. He was asked if it would be difficult for him to sit on this case. He said it would be, other than the fact that I see myself as a logical person, compartmentalize and analyze only the evidence related to this single incident. And that he was very clear that any biases that may exist outside of this room cannot play into your verdict. And he said clearly, or at least answered in the affirmative, that if the evidence is deficient, they're not guilty.
Thank you. I agree with the defendants. Juror 166 was superlatively smart and thoughtful and careful in the way he, I think both in the way he thought about things and the way he expressed how he thought about things. There's no question in my mind that he has the perspective of exactly the type of person we want to be a juror, understanding it is about individual questions of evidence and guilt, or whether guilt has been proved or not proved. However, there is such a deep well of feeling and of perception and believed understanding as to the people and the groups and the issues involved in this case that, notwithstanding that clear-eyed view, I have serious concerns, and I'm satisfied that Juror 166 would not be able to try this case impartially and without prejudice to the substantial rights of the defendants. For that reason, the defendants' request to release Juror 166 for cause is granted over the objection of the state.
168, Your Honor.
I'll join.
Join.
The state will oppose.
Thank you. Mr. Buchal.
Juror 168 in the questionnaire absorbed the narrative that Antifa was nothing but an idea to be against fascists, whereas Patriot Prayer was an organized group. Juror 168 stated in the questionnaire probably attended events with Antifa, that Antifa is good for Portland, Patriot Prayer is not good for Portland, for the simple reason that white supremacy is bad. When questioned, 168 said that just seeing someone who did not wear a mask inside would make me question their personal choices, and I think would essentially mark it against my client for declining to wear a mask in the court, and regards that as unreasonable approach to risk management, which relates to the case, actually. This juror lived a block away from the patrolman's building that was under siege for many weeks, but had no negative sense about that whatsoever. One time went down there and walked, and it was the police's fault for clearing the street. Didn't see any violence ever. Didn't see any violence at all. It's been to lots of marches, women's march, reproductive marches. Never sees any violence. Mr. Lee questioned him about the way he talked about Patriot Prayer in the questionnaire. He described the views that he thought Patriot Prayer held as exceedingly abhorrent, totally opposed to his viewpoint, quite extreme, a direct opposition to his world views. But like juror, and it was another smart juror. This is a juror like he was the one who pointed out that the Latin root of policeman, polis, man of the city. This is not a stupid person. This is a person who has an excessive, like 166, has an excessive belief in their own rationality, and so it was quick to dismiss the bias. Well, I'm trained in conflict mediation, so I can be unbiased. And I just think he's another 166.
Thank you. Mr.
Your Honor,
Schultz.
I agree. I would emphasize he had a very strong anti-law enforcement bent, which is in and of itself not necessarily indicative of bias, but the concern would be he's going to view Patriot Prayer as a proxy for law enforcement. If we got a free pass by law enforcement to go down to Cider Riot would be my fear, because the notes I have on the comments he made, every time he saw a rally, he was critical of the police for breaking it up too soon. And my concern would be the way the facts in this case are going to come out. He may look at Patriot Prayer as kind of a proxy for Portland Police Bureau's anti-BLM stance, which he articulated strongly.
Thank you. Mr. Doyle.
Well, my problem was alluded to by Mr. Buchal very quickly. When he was pressed whether he could be fair or not, he says, I can be fair. I have mediation training. We do not need mediators. The jurors are not mediators. They are fact finders. They are not to balance and try and get the parties to agreement. They are to find facts. And I think his mediator training will make it almost impossible for him to actually see the facts as they are and not try and split the difference, cut the baby, and do something. I mean, it's a training. He seems very well trained, and that's great. I love mediators, but not as jurors, because jurors are not mediators. They are fact finders. And I do not think he can be fair.
Thank you, counsel. Mr. Hughey.
From the state's perspective, Your Honor, there is not a basis in the record to be skeptical of this juror's or prospective juror's rationality. They answered, I can be aware of my biases. I'm pretty good at recognizing them. Would that be difficult? No. I think you can approach things logically and rationally. That's the way the system is set up. And then in that situation, I could rationally approach it. The anecdote or example they gave was when you walk by somebody on the street, you might make a million instant decisions, snap decisions, but that's not the same. They contrasted that with the importance of using more information to make a sober deliberation, as would be required in this process. And so we oppose the challenge.
Thank you, Mr. Hughey. The challenge is granted. I find that Juror 168, notwithstanding good intent and I think strong optimism in his ability to be fair, I think because of the other views he has expressed, would have great difficulty, and I am satisfied, would not be able to try this case impartially without prejudice to the substantial rights of the defendants. So Juror 168 is granted, or is released for cause over the objection of the state. Mr. Buchal.
180.
I join.
I join.
The state opposes.
Thank you. Mr. Buchal.
continuing with 180, we may have to go back a notch, but continuing with 180, 180 said in the questionnaire. But 180 is an example of a different type of juror, one who holds very, very, very extreme views, and then presents an image of neutrality that we certainly have reason to question. This juror believes that one of the most prevalent causes of crime generally is violence against LGBT plus and POC. This juror has participated in multiple George Floyd gatherings. This juror says Patriot Prayer is actively discriminative, whereas the anti-fascists support equality for all. Antifa is good for Portland. Patriot Prayer is not good for Portland because members intend and have caused physical and mental pain against protected groups, including public discrimination. So there's an intense personal identification with protected groups and a belief that Patriot Prayer is a false belief that Patriot Prayer is aimed at those protected groups. When it came to the questioning, it got very mushy. There were claims that Antifa is just an idea, a claim that no one, it got very mushy. But the admission was there that there was a pretty strongly negative view of Patriot Prayer. And we think on that basis that Juror 180 is not able to be unbiased. I understand that this is the witness who talked about putting puzzle pieces together, but we think that in substance, the path is there. It's like one of those children's puzzle pieces where they will only fit in one place because of this specific and powerful belief against Patriot Prayer.
Thank you, Mr. Buchal. Mr. Schmaltz, anything to add?
Nothing to add.
Mr. Doyle, anything to add?
Nothing to add.
Thank you. Mr. Hughey.
I'm scratching my head, and I don't think the court is incorporating these arguments into its decisions on any of the challenges, but I am scratching my head to understand how somebody identifying prevalent types of crime as violence against LGBT populations and people of color is somehow eroding their ability to be fair and impartial in this trial.
Connected that to a person or an organization that she associates with. I don't think I see that connection here either.
And I don't, okay. Beyond that, Your Honor, I don't have a whole lot of notes on this, sir, and I just don't think the record supports a strike or a strike for cause.
Okay. Mr. Doyle first, then back to Mr. Buchal. We need to start picking up the pace here.
29, criminal activity of law enforcement officers. That was the crime that is not properly punished. That was her statement on 29.
Okay.
And I don't want to say anything more, but I think that's sufficient to say that she cannot be fair at all.
I was just going to respond to Your Honor's comment that you didn't see the tie-in, and we view the statement that Patriot Prayer is actively discriminative and is focused on causing pain against protected groups, and then this focus about how that's the tie-in we see. We see a focus that is inconsistent with unbiased decision.
Thank you. I understand the argument. I'm going to grant the challenge for cause, but on a very narrow ground. Much of what was talked about it doesn't move the needle a lot, I don't think. But what does is Juror 180 has read multiple media reports, has a very strongly negative view, and did not, I don't think was ever asked whether she could overcome those negative views. I don't have her ever saying that she thought she could be fair, notwithstanding those negative views. In view of that record, I am satisfied that Juror 180 could not try this case impartially and without substantial prejudice to the rights of the defendants. And so the defense requests to excuse Juror 180 for cause is granted.
187.
Thank you.
I joined Judge.
Thank you.
Join.
Thank you.
The state opposes, Your Honor.
Very well. Ready when you are on juror 187, Mr. Buchal.
Juror 187 said in the questionnaire that Patriot Prayer are dangerous extremists and dismissed Antifa as a nebulous enemy called out by the political right, that Antifa is not a group, it's just people, and that people standing up to tyranny is not bad. Patriot Prayer is not good for Portland because they are dangerous extremists with guns. I do not like them, is what 187 said. This juror, yeah,
Thank you.
this Mr. Lee questioned him about Mr. Lee established that the view of Patriot Prayer had come from the media reports. We've documented the extent and pervasiveness and contents of those media reports. This juror said that it was a pretty strong negative view, and this juror said that view was not going to change.
Thank you. Mr. Schmuntz, I think that was joined but not adding. Mr. Doyle joining but not adding. Mr. Hughey.
The state's opposition, Your Honor, is that we think that the record doesn't reflect a link between the pre-existing feelings about the groups and the individual defendants and the ability to be fair and impartial.
Thank you. I respectfully disagree with the state. My notes in my memory are that juror 187 identified Patriot Prayer as a particular group of people, I think was the exact quote, and then said, "I do not like them." That is sufficient in my mind to suggest that juror 187 would not be able to try this case impartially without substantial prejudice to the rights of the defendants. Juror 187 is excused for cause at the request of all defendants over the objection of the state.
Juror 189 is an interesting case and has a negative view of both Antifa and Patriot.
Let me just see if it's. It's okay. Thank you.
No.
Not joining.
189?
Yes.
I am joining.
Very well. Opposing? Is the state opposing?
No.
Not opposing.
Not opposing.
Okay. Juror 189 then is understanding that Mr. Schmuntz is not objecting on behalf of his client. Nope. Juror 189 is excused with the stipulation of all parties.
229.
Not joining.
Not joining, Mr. Schmuntz. Thank you.
Sorry, 229?
229.
We're joining.
Thank you.
And the state would oppose the challenge.
Mr. Buchal.
229 says that Patriot Prayer is not good for Portland and tends to threaten other groups with speech, congregation, occasional violence. In the questioning, 229 referred to these as strong negative views. They still hold. There's no chance they will change. The juror testified that the juror had drawn conclusions from the reports in the media, particularly Twitter feeds. Now, I understand that when pressed, the juror said, again, used this compartmentalization thing and claimed to have a special skill for compartmentalization. And so we don't think that that's so easy as the juror thinks it is.
Thank you. Understand you haven't joined Mr. Schmuntz. Do you wish to be heard?
No.
Thank you. Mr. Doyle, do you wish to be heard?
I was just looking at the questionnaire and there was 54A. I can only answer that there was a confrontation and it got out of hand at Cider Riot. I think what they've heard is enough to make them unable to be impartial.
Thank you. Mr. Hughey.
The juror did indicate having a preliminary negative view of Patriot Prayer and then interjected that that's not to say that they could not approach this trial unbiased. There was actually, I think, no follow-up on that. And then much of the following discussion was related to the imagery surrounding the Trump flag. And the juror was persistent in saying, I can still be fair and impartial. You can set those aside and compartmentalize it, as the other lady said.
I thought 229, in addition to being the last on the panel, was a very close case. Mr. Buchal?
At the last, I have to go back and do one more on that.
Okay, he was last on the panel. I did not think that the record did not satisfy me that this juror could not be fair and impartial. There are some feelings the juror spoke, but they're not of the kind of moment that some of the other jurors spoke of. And juror 229 appeared both able and willing, and I believe he would set those feelings aside and could try this case impartially. Mr. Gibson and Mr. Lewis's request to remove juror 229 for cause is denied.
177, Your Honor.
I don't mind going backwards, but just so I know where we are, is this the last one?
Yes.
Okay, juror 177.
Sorry.
Not at all.
I'm not joining, Judge.
Thank you.
I'm not joining either.
Thank you.
One seven seven. The state does oppose.
Ready when you are, Mr. Buchal.
The only issue with this juror is that this juror totally denied any impression of increasing crime or disorder in the city of Portland, which seemed a really outlandish point of view, and then said that it was hard to be impartial, but why or how didn't really come out as well as I would have liked, at least in my notes, and that's what I know.
Thank you. Understanding you're not joining, do you wish to be heard, Mr. Schmanzes?
No, Your Honor, thank
Mr.
you.
Doyle, I know you're not joining. Do you wish to be heard?
No, thank you, Your Honor.
Mr. Hughey?
Your Honor, I don't think the record is anywhere close on this one. An impression of crime rising or falling that Mr. Buchal doesn't agree with is nowhere near a basis to strike somebody for cause.
I think I understand what's animating the motion, but I agree that the record just isn't sufficient to satisfy me, and I'm not satisfied that juror 177 would be unable to try this case impartially, and therefore Mr. Gibson's request that juror 177 be excused for cause is denied. Let me read for you who I have released for cause from this panel. But first, let me put them in numerical order. So released, I have jurors 81, 148, 158. You know what, I promised you numerical order, and that is not happening at all. Sorry, let me make one correction, and then I think I can deliver on my promise. I'm going to take that from the top. Juror 81, juror 139, juror 142, juror 146, juror 148, juror 158, juror 164, juror 166, juror 168, juror 180, juror 187, and juror 189, I all have as being excused for cause.
I agree.
And Judge, just because we have new lists, I
Sure.
believe two of those jurors you said probably aren't on our new list because one was excused for a plane trip and
Okay.
That's right. Sorry, those. So 130, for example. I'm sorry.
148 and 158, where I was looking
48
for
and
the.
158 are confusing, yeah.
Yeah. That's an us problem. The court still has it right, and we agree.
I think so, yeah.
I should have included 130 as the short version. I think we're good.
We are.
Okay. Jurors, and then just for the record, jurors, all defendants requested that jurors 135 and 140 be released for cause. Those requests were denied by the court. Mr. Gibson requested that jurors 151 and 177 be excused for cause. The court denied that request. And Mr. Gibson and Mr. Lewis jointly requested that juror 229 be excused, and the court denied that request. Okay. Let's go off the record and take a 5-minute break while we get some new paperwork and get organized.
Okay, we'll go on record and we'll recall that. 1 second.
All right.
5-minute opening.
With all counsel and all parties, we are outside the presence of the veneer. Last call. Does anyone not stipulate to doing this orally? Okay, I accept everyone's stipulation, and that's how we'll proceed. We have populated the jury box with the 14 lowest numbers, and this is what that looks like. Juror 8 is in seat 1. Juror 9 is in our first alternate seat of seat 2. Juror 10 is in seat 3. Juror 11 is in seat 4. Juror 5 is in seat, Juror 14 is in seat 5. Juror 15 is in seat 6. Juror 16 is in seat 7. Juror 22 is in seat 8. Juror 23 is in seat 9, which is our second alternate seat. Juror 26 is in seat 10. Juror 28 is in seat 11. Juror 29 is in seat 12. Juror 30 is in seat 13. Juror 31 is in seat 14. Each of the defendants has 6 peremptory challenges plus 1 for the alternate seats. More often than not, all of the parties agree that rather than doing it as 6 plus 1, that everybody can just use any challenge. So it just becomes 7, and any party can use any challenge against any juror at any time. Would the parties like to so proceed?
The state would.
Okay. I saw Mr. Buchal say yes, please. Mr. Gibson?
That means theoretically, Judge, I could exercise every single challenge on an alternate.
Correct.
Okay.
Or you could use, the way it sometimes goes the other way is you could use 0 challenges on an alternate. Is that what you want to do, Mr. Schmatzies?
I'm fine with that.
Okay. Mr. Buchal?
I know it's obvious, but
Yep.
the alternate in seat 9 is the first alternate, and the alternate is
It's a fair question. The statute actually, I'm happy to do it that way, but the statute actually says we are to determine by random draw. If an alternate needs to move, if we lose a juror and an alternate needs to become a full-seated juror, that it is picked randomly. I would probably flip a coin. We can do it that way, or we can, if everyone stipulates that the lower seat is the first alternate, which is how I often do it in civil cases, I'm happy to do it that way. Mr. Lee, I think Mr. Gibson's trying to get your attention.
I'd like to do that. Have the lower seat be the first.
For the first alternate? Okay, fine with me. Okay with the state?
That's fine.
Okay.
Yeah.
Mr. Doyle?
Well, I was leaning toward random draw, but I've been outvoted.
Okay, and accept and,
Yeah,
and
that's
join.
fine.
Okay, so that's what we'll do then. So rather than the random draw, the lower seat, which is going to be seat 2, will be the first alternate. If we need one alternate, that person will become the sitting juror. Seat 9 will be the second alternate. All right, good question. Again, we're going to go defendant by defendant, alternating with the state, 2 strikes at a time. You may pass with strikes remaining. If you pass, you are accepting the box as constituted at the time that you pass, and you may use any remaining strikes only to someone who is new to the box since you passed. Does anyone need a greater explanation of that, or does that make sense? Okay, as a reminder, no one's moving in the box. They're either sitting where they are, or they are removed and someone is parachuting right into their space.
Judge, I'm going to go first, so let me know when you're ready.
Okay, thank you, Mr. Schmutzky. Give me 1 second.
We had said 23 and 22.
Mr. Schmutzky, I'm ready for Mr. Schultz's first peremptory challenge.
Juror 30 in seat 13.
Juror 30 in seat 13 is struck with Mr. Schultz's first peremptory challenge. The first juror out of the box is juror 33, and juror 33 is now in seat 13.
You just announced your first one. And which one was that?
30.
30. Okay, thank you.
30 is struck in seat 13, and juror 33 is now in seat 13.
And my next strike, Judge, is seat 10, juror 26.
Thank you. Juror 26, who is seated in seat 10, is struck with Mr. Schultz's second peremptory challenge. That moves the next juror out, which is juror 36, into seat 10. Ready for the state's first of 7, 14, 21, 21 challenges for the state.
State's first peremptory challenge will be juror number 11, who's currently in seat 4.
Juror number 11, who's seated in seat 4, is struck with the state's first peremptory challenge.
Your Honor, I'd like to make a Batson challenge in a moment.
Very well. That will put juror number 40 into seat 4. And I understand there's a Batson challenge. Go ahead.
Your Honor, I'll tell you that I'm making that to start the record now. This is something I was concerned about. There were very little questions, if any, asked of juror number 11 by the state. I believe that they're making that peremptory exclusively based on race and gender, which matches the defendants in this case. I don't believe they asked him hardly any questions, if any at all. And the reason I was clued into that issue was when we were doing our first round of strikes for cause. The only one of our 4 cause strikes that they did not object to was, again, another person with the same racial and demographic or gender, was it gender or sex? I get those confused. Male, white was the only one that they did not object to our striking. So I'm already seeing that pattern, and I want to flag it now.
I'm sorry, what is the pattern?
Right now, juror number 11 is a white male. They asked no questions.
Okay.
The 3 defendants are white males. And they've developed no record for striking.
Thank you. Mr. Hughey.
So the first part of the Batson inquiry is whether the court even agrees that on its face it appears the challenge may be based on nothing other than race, and only then does the burden shift to the striking party to articulate a race-neutral reason. I don't think on that record and with this panel, that first line of inquiry is even satisfied to turn to the state to ask for a race-neutral reason.
I nonetheless do.
Okay. This is a 49-year-old male juror who identified in their questionnaire as moderate. I would note that they're from a more rural part of Multnomah County, actually almost to Columbia County in Scappoose. Unlike numerous other jurors indicated that they did have law enforcement family members. And actually in court presented in a style of dress that was strikingly similar to many of the participants in the video. I don't know, it was a Whiskey Tango Foxtrot T-shirt and sunglasses on the head, and actually, to me, it kind of looks similar to one of the people that I had seen in the video. It's worth adding that the deficiency in questioning is mutual on both sides. And I think there are ample reasons as well. The case that just came down from the Supreme Court yesterday, State v. McWoods, emphasizes that an important part of the analysis is the comparative strikes to other jurors, or weighing, I guess, against other jurors. Every other juror on this panel is also white in the box right now.
Thank you, Mr. Hughey. I find that, go ahead, Mr. Lee.
I just wanted to add a couple of things for the record. As far as there were multiple jurors with sunglasses on their heads, and I'll leave it at that.
Well, I find that Defendant Gibson has not made a prima facie showing that the peremptory strike was based on race. However, even if he had, I find that the state's race-neutral explanation for the peremptory strike is made, and that in consulting all of the circumstances that bear on racial animosity, I am determining that the defendant has not shown purposeful discrimination by the state. State's second peremptory challenge.
The state will excuse here. It's not in the box right now.
We could have a moment, Jeff.
Sorry. And just to confirm, I think I asked this yesterday, but it's appropriate to make strikes outside of the presumptive 14 box.
It is.
Okay. The state will excuse juror number 85, who I believe is currently in the slotted 28th spot.
Juror 85, who's outside of the box, is struck with the state's second peremptory challenge. Who's next for the defendants?
Mr. Doyle, you ready?
No, I'm third.
Okay.
I'm third.
Okay, you're good.
66 female, retired food service.
Don't make me, I've already planned mine. Mine go second if you want. I thought they wanted to go second.
They will.
Ready for Mr. Gibson's first peremptory.
Thank you, Your Honor. Okay, Joey Berman. 22, Your Honor.
With Mr. Gibson's first peremptory, Mr. Gibson strikes juror number 22, who's currently in seat 8. The first out of the box is juror number 41. That's going to move juror number 41 into seat 8.
This is going to get done either way. But we could.
Yeah. Makes sense.
41, Your Honor.
Juror number 41, who has just moved into seat 8, is struck with Mr. Gibson's second peremptory challenge. And that moves the first juror out of the box, juror number 47, into seat 8. State's next peremptory.
The state will excuse juror number 90.
Juror number 90, who's currently out of the box, is struck with the state's third peremptory challenge. State's fourth peremptory challenge.
The state will excuse juror number 60.
Juror number 60, who's out of the box, is excused with the state's fourth peremptory challenge. Ready for Mr. Lewis's first peremptory challenge.
36.
Juror number 36, who's currently seated in seat 10, is struck with Mr. Lewis's first peremptory challenge. That moves juror number 49 into seat 10. Ready for Mr. Lewis's second.
14.
Juror number 14 is currently in seat number 5, is struck with Mr. Lewis's second peremptory challenge, and that moves juror number 52 into seat 5. I'm going to reset the box for everybody, make sure we are all on the same page. Juror number 8 is in seat 1. Juror number 9 is in seat 2, which is our first alternate seat. Juror number 10 is in seat 3. Juror number 40 is in seat 4. Juror number 52 is in seat 5. Juror number 15 is in seat 6. Juror number 16 is in seat 7. Juror number 47 is in seat 8. Juror number 23 is in our second alternate seat, seat 9. Juror number 49 is in seat 10. Juror number 28 is in seat 11. Juror number 29 is in seat 12. Juror number 33 is in seat 13. Juror number 31 is in seat 14. Does that track with what everybody has? Okay. Mr. Schmontzes, are you ready with Mr. Schultz's third peremptory?
One moment, please.
Sure.
Are we coming back to the state?
Yes.
Yeah.
I'm sorry,
Yeah.
State's turn. Sorry, thanks. State's fifth peremptory.
Let's see. So we'll just get these. They're not too far. The state will excuse juror number 100.
Number 100 is excused with the state's fifth peremptory challenge. Juror number 100 was out of the box.
And the state will. The state will excuse 103.
Juror 103 is excused with the state's sixth peremptory challenge. Juror 103 was also out of the box.
Mr. Schmontzes, do you want to have a conference before we go further?
We'll go off the record for a moment. We'll mute the microphones.
Oh, take care.
You're off record, like.
Mr. Schmontzes, for real this time. Mr. Schultz's third peremptory, please.
Judge, in seat 8, juror number 47 is struck.
Juror number 47, who was in seat 8, is struck with Mr. Schultz's third peremptory challenge. That moves juror number 53 into the box.
Juror number
Into seat 8.
Oh, and in seat 5, juror number 52 is struck.
Juror number 52, who was in seat 5, is struck with Mr. Schultz's fourth peremptory challenge. That moves juror number 59 into seat 5. Next out of the box is juror 61.
Just one quick thing I wanted to raise. I think there's a standing order related to the use of devices for non-parties, and I'm just a little concerned about what's going on here related to the cell
Okay,
phone use.
there is a standing order in this case. No one who is not on this side of the bar, that is to say who is not a lawyer or a defendant, may use an electronic device in this courtroom without prior permission of the court. If somebody wants to check in with the clerk, they can. Otherwise, no devices. Mr. Hughey.
Let's see. The state will excuse juror 112.
Juror 112, who is out of the box, is struck with the state's seventh peremptory challenge.
And 119.
Juror 119, also out of the box, is struck with the state's eighth peremptory challenge.
I'm sorry, Judge, could you repeat who the was? I didn't get another.
I believe Mr. Schmontzes, Mr. Schultz's third strike was juror number 22 in seat 8. Does that track?
Yes.
When did they? The number. Gibson had done 22.
Oh.
So that's why,
Oh, I'm sorry.
that was the very first strike, that's the only reason.
It was 22. Okay, let me, hold on. Oh, I'm sorry. Well, I'm sorry, it was 47.
Yes, sorry, Judge,
47.
it's
That's what it was.
47 and
Yeah.
52.
Who was in seat, yeah.
Right.
Yeah, that was the side that I found. Okay, thank you.
Oh, yeah.
We want to stay in the box. 59. And then 61 will come in and we'll strike.
Okay. 59, Your Honor, for Gibson.
59 has been struck. I'm sorry, 59 has been struck by Mr. Gibson
Okay.
with his third peremptory challenge. Juror 59 had been in seat 5. That moves juror 61 into seat 5.
I guess not, never mind.
Oh, yeah, that's the.
Go ahead and do 61.
61 is the lawyer. Yeah, 61.
Yeah, that's one we're doing right now. When the court's ready.
Gibson's got one more.
Oh, 61, Your Honor.
I'm sorry, I didn't hear that. Thank you.
61.
Thank you. With his fourth peremptory challenge, Mr. Gibson strikes juror number 61, who was in seat 5, not for very long, and moves juror 62 into seat
I'll let you,
5.
okay?
I have one that I'm gonna make.
Jurors 64 and 65 are the next two out of the box.
Wait, they're out of the box or they're in the box?
They're in the box, so, no, the next one's in, 64 will go in, that's the judge. We still had 8, 9, and 10 on our list.
When ready, we're ready for the state's ninth peremptory.
Yeah.
You can do 10.
Okay. The state will excuse juror number 97.
Juror number 97, who's out of the box, is excused by, or is struck with the state's
And then
ninth
strike
peremptory
64,
challenge.
64. That's the judge.
No, but I have it written down.
And juror number 8.
Juror number 8, who is seated in seat number 1, is struck with the state's
And then 64 is good.
10th peremptory challenge, and that moves juror number 64 into seat 1. Would anyone like me to reset the box for them?
I'm
Your
trying,
Honor, please.
I'm tracking.
Sure. In seat 1, we have juror number 64. Seat 2, our first alternate seat is juror number 9. Juror number 10 remains in seat 3. In seat 4 is juror number 40. In seat 5 is juror number 62. In seat 6 remains juror 15. Juror 16 remains in seat 7. Juror number 53 is in seat 8. For seat 9, which is our second alternate, is juror 23. For seat 10 is juror 49. For seat 11 is juror 28. For seat 12 is juror 29. Seat 13 is juror 33. And seat 14 is juror 31. Anyone disagree or have any issues? All right, we're up to Mr. Lewis's third peremptory.
10?
Juror number 10, who is in seat 3, is struck with Mr. Lewis's third peremptory challenge. And that moves juror number 65 into seat 10.
Seat 64. I mean,
Juror
seat
64.
1, juror number 64.
Thank you, Mr. Doyle. Juror number 64, who was briefly in seat 1, is struck with Mr. Lewis's fourth peremptory challenge. And that moves juror number 71 into seat 1. I have 65 as being in 10.
Judge, I think I heard you put someone in seat, 65 in seat 10, but I thought 65 was already in 5 or 3.
We got 2 65s up there.
That's what I've done.
Okay. I'm sorry. 65 was in seat 3, not seat 10.
71.
It's 70.
That moves 71.
Yeah, 71 is good.
71 is still in seat 1. And that moves, and I'm sorry, this last strike, Mr. Doyle, was to, or not Mr. Doyle.
The only thing that can.
It was Mr. Doyle striking juror number 64 as Dennis Lewis's fourth.
Okay. So that, I'm sorry, so that's juror number 65 is in seat 3, juror number 71 is in seat 1.
Correct.
Okay. all for the catch. I move the juror number, not the seat number, or vice versa.
2 and 9.
So it's ours, so-
Everybody's clean.
And we're up to the state's 11th challenge.
Thank you.
Just a minute.
Yeah.
The state will excuse 121.
Juror 121 out of the box is struck with the state's 11th peremptory challenge.
That was the guy. And 31.
And 31
Yes.
with the state's 12th peremptory challenge. The state,
Can I ask a question before we
You may.
strike that off the list? I could just be totally confused, but I thought once you start striking outside of the box, you've passed on the people in the
no,
box.
only if you pass, meaning only if you don't use the strike at all.
Gotcha. Okay, thank you.
You're welcome. Juror number 31 is struck with the state's 12th peremptory challenge. Juror 31 had been in seat number 14, and that moves the first juror out of the box, juror number 73, into seat 14. Because of other strikes, the next three jurors out of the box are jurors 93, 94, and 96.
Out of the box, meaning they've been struck.
No, they'll be coming in.
Oh, in,
Parachuting in.
oh, coming into the box.
On deck.
On deck.
Oh, deck,
In the hole,
okay.
in the hole and on the deck.
Now, we're back to you, Mr. Schmonzes, right?
Yeah.
Do you want to take a break and
Uh,
conference, or?
I know what I need to do. I think we should conference after that first round.
Okay, all right.
Your Honor, I'm going to strike seat 9, number 23.
With his 5th peremptory challenge, Mr. Schultz strikes juror number 23 in our second alternate seat, seat 9. And that moves juror 93 into that alternate seat, seat 9.
And Judge, I'm satisfied with this panel. I'm going to reserve my last strike.
2 more, actually.
Because of the alternate one.
Oh, yeah, thank you.
Okay. So passing.
Yes.
Okay, I need to make a note of who's in the box.
How many strikes have you used? 6, 5? I thought you just struck 9 and 23. Oh, no, you did not strike 9.
I haven't struck 9.
He said 1. Oh, okay. I thought I heard him say you struck 1.
Seat 9.
That's where my confusion came from.
Okay, we're up to the state's 13th strike.
Let's see, the state will excuse juror number 15.
Juror number 15 in seat 6 is struck with the state's 13th peremptory challenge. You okay?
Yeah.
I'll pause.
And the state will
Hold
also
on,
excuse.
hold on, we
oh,
need to
sorry.
pause.
No, we're okay.
Okay.
I'm there now.
And that will move juror number 94 into seat 6.
And the state will excuse juror number 16.
Juror number 16, who was seated in seat 7, is struck with the state's 14th peremptory challenge. And that will move juror number 96 into seat 7. Because of earlier strikes, the next few jurors up on deck in the hole, et cetera, are 106, 114, and 118. We're up to Mr. Gibson. Pass this slightly earlier.
9,
Oh, no, there's a picture, but you don't have it.
you're number 94, Your Honor.
Juror number 94, thank you, Mr. Lee. That's with Mr. Gibson's 5th peremptory challenge. He strikes Juror number 94 in seat 6, and that moves juror 106 into seat 6.
I like it. I had it for a second.
Except for the alternate. But if we-
Oh, that's not.
Really?
I changed a lot.
We're gonna push ones and
On page.
Your Honor, my client would very much like to have a conference with us, and I'm sure
That's
everyone
fine.
could benefit with
I,
me.
I think it would be better. Can we keep it to 10 minutes?
Sure.
Okay, 10 minutes. We'll go off the record.
Well, I'm gonna need all of it.
We're back on the record. We're outside the presence of the veneer. All parties, all attorneys are present. And I believe we're up to Mr. Gibson's sixth. No. Yes. Mr. Gibson's sixth peremptory.
And we are going with 114.
Juror 114, who is the first out of the box, is struck with Mr. Gibson's sixth peremptory challenge. This brings us to the state's 15th challenge.
The state will excuse juror number 53.
Juror number 53, who is in seat 8, is excused with the state's 15th peremptory challenge. And that moves juror 118 into seat 8.
Write that down. 53. And then and juror number 62.
Juror number 62, who's in seat 5, is struck with the state's 16th peremptory challenge. And that moves juror 125 into seat 5. The next several waiting to come into the box are jurors 131, 135, and 137. Would anyone like me to reset the box?
Please.
Sure. In seat 1, we have juror number 71. Juror 9 endures in seat 2A, which is our first alternate seat. Juror number 65 is in seat 3. Juror number 40 is in seat 4. Juror number 125 has just come into seat 5. Juror number 106 is in seat 6. Juror number 96 is in seat 7. Juror number 118 is in seat 8. Juror number 93 is in our second alternate seat 9. Juror number 49 is in seat 10. Juror number 28 is in seat 11. Juror number 29 is in seat 12. Juror number 33 is in seat 13. And juror number 73 is in seat 14. Does anyone disagree? Okay. We are up to Mr. Lewis's fifth peremptory.
Juror number 125.
Juror number 125, who is in seat 5, is struck with Mr. Lewis's fifth peremptory challenge, and that moves juror 131 into seat 5.
And I think I'm going to reserve, and I'm happy.
Very well.
I'm not happy. I mean,
Subject to all of the motions to strike for cause, Mr. Doyle is otherwise satisfied with this panel and reserves Mr. Lewis's last 2 peremptory challenges. We will take a snapshot. Thank you. It saves me a lot of scribbling.
This is their last 2.
Yeah, and you have 2.
I finally got
You got your way, right? You got your strike. Made it count.
Talk about all these.
We're up to the state's 17th peremptory challenge.
Joey, I'm directed.
Yeah.
I get
State will pass this
in my
down.
craw.
State accepts the panel as constituted. That'll move us to Mr. Schultz's 6th peremptory.
Your Honor, I believe I'm satisfied, but just let me double check.
Very well.
So are we okay with the, are we okay with number 9 in the?
Yeah.
Take a look.
I'm satisfied, Judge.
Schmancy, thank you. Mr. Schultz accepts the panel as constituted. Back to Mr. Gibson for his 7th and final peremptory.
You know,
So is there some reason?
brain.
Your room.
Well, if they do, we can,
Push them.
if they do, we can come back and use it. Because 135 is not in.
We're using our last one.
And we're just gonna.
Okay, all right, okay.
We're good.
Mr. Gibson also accepts the panel. I believe we have a jury. To recap, make sure everybody's notes are the same. Juror number 71 is in seat 1. Juror number 9 is in our alternate seat 2. Juror number 65 is in seat 3. Juror number 40 is in seat 4. Juror number 131 is in seat 5. Juror number 106 is in seat 6. Juror number 96 is in seat 7. Juror number 118 is in seat 8. Juror number 93 is in our second alternate seat of 9. Juror number 49 is in seat 10. Juror number 28 is in seat 11. Juror number 29 is in seat 12. Juror number 13 is in seat 33. And juror number 73 is in seat 14.
That's juror 33 and seat 13.
What did I say?
13 and
Oh,
33.
Oops. Juror number 33 is in seat 13.
okay,
Stand, stand.
thank you.
Sure. Does everyone agree? We have a jury. We're going to go off the record just for a second so that we can start the process of counting those folks. We'll then go right back on.
Going off record.
Okay, we're on the record. We're outside the presence of the veneer. All parties, all lawyers are present. We've had a chance to talk about scheduling off the record. I appreciate everybody's engagement and willingness to think through things. Having had that discussion, my understanding is that all the parties have agreed, and I agree,
Okay,
that we're going to use tomorrow as a law day, and we're going to continue resolving the outstanding legal issues, including on jury instructions, and that we're going to begin with the jury, which has just been selected, at 9 a.m. on Monday. Does anyone wish to be heard on any of those issues? Have I misunderstood anything? Okay, that will be how we will proceed then, and we will go off the record.
Okay, we are off the record. Yeah.
Okay, well, I guess I'm gonna wait just a minute here just to make sure that they don't come back on the record. But considering it's after 4 o'clock, I don't expect them to. Yeah, it's done for today. The jury has been chosen, but they've decided to hold off the actual start of the trial until Monday morning. Tomorrow, it's going to be just them going over, as the judge said, law stuff. So they're going to be, focusing on the rest of the in limine motions that they had started this morning. And, any other questions of legal stuff, or maybe if they have to go over information about the questions with witnesses and things like that. I'm gonna go ahead and plan for starting upstream at 9 o'clock tomorrow morning, and we go from there and see what happens. But yeah, it seems like they haven't shut off the stream, but I really expect they're going to in just a minute here. So I'm gonna go ahead and shut things down now, and